Hello everyone, welcome and thank you for joining us. Today we are happy to have joining us Nicholas Gould. Nicholas is a partner in the specialist construction, engineering, and energy lawyers, Fenwick, Elliott, where he conducts a mix of international dispute resolution and non-contentious work. He is a solicitor advocate, chartered surveyor, accredited adjudicator, and CEDR lead mediator. He sits as arbitrator and on dispute boards. He acts for contractors, employers, and governments in the building, construction, engineering, infrastructure, transport, energy, oil and gas, and process engineering sectors. Nicholas is a visiting professor at King's College London and vice president of the ICC's Arbitration Commission. He is president of the DRBF and past chairman of the Society of Construction Law. Before we get to his presentation, I would just like to briefly introduce the ICCP to anyone who is joining us for the first time today. So what is the ICCP? Well, we are a professional members organization designed to recognize those who have the skills, qualifications, and expertise in the professional management of construction claims. Our objectives are to establish international professional standards for the management of claims and give recognition to those who have gained that knowledge, as well as help educate those who wish to gain experience in the management of claims. Why is there the need for the ICCP with so many professional organizations related to the construction industry? Well, our members come from many different professional backgrounds, from engineering, quantity surveying, project management, etc., and have moved into claims. And until the ICCP was established, there was no institute that specifically recognized those who have the specialist knowledge, experience, and skills to manage, prepare, and respond to claims to the highest levels of professionalism. To briefly introduce our steering committee, we have the executive officer, Andy Hewitt, our elected president, Paul Gibbons, and 3 fellows, Christian Grosskopf, Lee Sporle, and Mark Watson, who were elected by the membership. In terms of membership, we have 3 individual levels, associate, member, and fellow, each of which comes with its own set of requirements that must be met in order to achieve that level of membership. We also have a corporate level of membership for companies who specialize in claims or have departments that specialize in claims. So what are the benefits of membership? Well, we have a private members area with a growing knowledge base of articles, white papers, case studies, etc. on contractual and claims topics. We have a growing library of practical templates to help our members save time while refining their claims administration and management skills. We have practical technical CPD in the form of the ICCP Academy. We have a private LinkedIn group where members can discuss their contractual questions. We offer industry exposure in the form of a searchable database of members on our website, as well as the usual certificate of membership that shows the designation, as well as a membership logo, which can be displayed in an email signature, LinkedIn profile, CV, etc., wherever you would like to show your membership. We also have an optional register of claims practitioners for our practitioners who would like to increase their web presence. If you'd like to know more about membership, please visit our website, instituteccp.com, or email me, jennifer.smith@instituteccp.com, or membership@instituteccp.com, and I'll be happy to answer any questions you have. And now on to today's presentation.
Okay, so everyone hopefully can see the main screen now, which says the increasing role of dispute boards, rather than the split screen, I'm hoping. So it's a pleasure to see you, Mark, and a pleasure to have so many of you on this call today. I'm going to look at dispute boards, and I'm going to try and keep the chat open as well, so I can try to keep an eye on any points that come up. It doesn't seem to be working just at the moment. I am just trying to adjust it, but it's not going to do it, I don't think. Sometimes I have a bit of a struggle with that. Anyway, never mind. Let's launch ourselves into it and see how it goes. So, What am I going to look at then today? So what I want to do is look at what a dispute board is. And I realize that some of you will be experienced in this area and others might not actually know much about this area. So what I'm going to try to do is launch into it at a low level and then build up fairly quickly and deal with some of the key topics as I see them. So first of all, dispute board really is an experienced and impartial panel, maybe 3 people or just 1. That's the most common combination. I think it's 3. You do sometimes see sole members and occasionally more than 3, but I'll talk about that later. And basically the idea is that they're organized at the start of the project. So they join your project as an impartial panel with an avoidance function and a dispute resolution function. So the idea is that the parties provide the DB, the dispute board, with key documents like the contract and progress report so that they become familiar with the project and the participants. For me, it's about understanding the people and the personalities. So when I sit on a dispute board as a standing member on a project that's live and running, it's about knowing who the people are, as well as understanding the project, because disputes are resolved by people, they're developed by people. Misunderstandings are all due often to communication, the way people behave, and it's really important, I think, if you can have a successful project and a successful dispute board, to know the people. Then you'll have joint meetings with the employer and contractor, and usually the engineer. So imagine every 3 months the dispute board visits the project, has a walk around the project, and then spends the afternoon talking to all of the participants for like a progress meeting, really, talking about the progress, looking forward to what the completion date might be, and talking about any issues or problems. And of course, the idea really is to encourage discussion at these meetings about time and money and quality. And I think what's interesting from my time in the construction industry is that you can have regular meetings on projects and never really address the real problems. So, for example, I mean, if the project is halfway through and it's clearly running late, often at these progress meetings, delays are reported, and the contractor, wanting to be helpful, will say, we were in delay, but we're hoping to gain back some more time. And the employer will say, well, we see they're in delay, but looks like they're going to try to pull things forward. Isn't that great? And it's not until you get late in the day that you realize that this hasn't happened and it can't happen, and the parties fall out. So one of the good things about a dispute board is that early on they can start to address that. They can say, well, looking at the program you've currently got and looking at the progress on site, you're not going to finish, are you? How are you managing that? If you're going to finish still on time, how have you adjusted the activities going forward? And start to consider that and address that early on. And then, of course, there's the financial implications of all of that. So really, it's about trying to encourage dispute resolution at job site level, to use the American expression, which is where this all came from, and possibly to give advisory opinions, ideas and suggestions about what you think might happen if a formal dispute is referred, or what you think the answer is to a particular problem that they've got. And then you can hold informal meetings, or you could make a decision, a written decision about a particular dispute that's been referred. If we look at the development of dispute boards, I suppose you trace it back to the 70s, not dispute boards in the UK, but adjudication in domestic subcontracts. Some of you will know the old domestic forms, DOM 1, DOM 2 from that era, and they had a simple adjudication provision allowing an adjudicator to decide whether any set-off could be made by a main contractor in relation to a payment application. Not used much, and therefore not very effective. But in relation to DRBs, in the 70s, they start being used in relation to tunnelling projects. So the infamous sort of one that is referred to as the Eisenhower Tunnel in the mid-70s. 3 engineers were engaged as dispute review board members. The project was successful in that these engineers followed the project and helped resolve any difficulties, and it grew in the States from there, and it grew internationally. So when we get into the 80s, there's this dam project in Honduras, and then there are more. So as we get into the 90s, we see DRBs being used around the world. Not that much, But then we get a boost from FIDIC. FIDIC puts a DRB supplement in its red book. It's only an option. The World Bank then makes them mandatory for all finance projects in excess of 50 million, and that's still the case today. So suddenly people do start to use them. They feel that they should be. We get the Housing Grants Act in the UK. Now this is 28-day quick-fire adjudication domestically in England and Wales and Scotland. And that's been with us now for over 20 years. The Asian Development Bank and EBRD and others start to adopt dispute boards. So this is end of the 90s now. So over the past 20 years, a lot of momentum that was built up in the 90s has really then come to the fore. So when we hit 1999, FIDIC introduces a standing dispute board in its red book. So you're supposed to have them from the start. And then ad hoc for yellow and silver. So yellow is design and builder, silver is the EPC turnkey contract. The ICC, the International Chamber of Commerce, these are the people that run international arbitrations under the FIDIC rules and very, very widely used, produce their own set of rules. And as we get a bit further on, the 9 multilateral development banks follow the World Bank and adopt dispute boards. In other words, they say if we're lending you money or granting you money for an international construction project, then you must have a dispute board. The Chartered Institute of Arbitrators produced rules in 2014. I drafted those for them. I led the drafting of that. And then FIDIC, when they revised their old 1999 contracts, went for a standing dispute board in all. And so when the 2017 edition came out, they have standing DAABs, in other words, dispute avoidance and adjudication boards. So they've done 2 things. They've gone from having ad hoc boards in the yellow and silver to having a standing board that follows the project throughout, appointed from the beginning. And they've emphasized the avoidance function. They're not just there to settle disputes when everybody falls out, they're there to avoid disputes too. And we see things like the World Bank now is also trying to strengthen their use in relation to gender-based violence and in order to promote more equality around the world in relation to how people are dealt with by the supply chain. So that's another challenge the World Bank is now taking on, and this is something that will become within the ambit of dispute boards to decide in relation to international projects also. So where are we today and what types of dispute boards do we have? Just to be clear about terminology, DRBs, dispute review boards, and what they do is make non-binding recommendations. DABs, dispute adjudication boards that make binding decisions. Now, so DRBs are traditionally the North America approach. That's what's used in the United States, non-binding recommendations. The rest of the world uses DABs, dispute adjudication boards, making binding decisions. The ICC introduced this idea of combined dispute boards that do both, which is sort of the way that FIDIC's gone, but still really FIDIC's emphasis is on decision making. But it just goes to show that the institutes have been thinking about how they can develop their rules. Then you have the World Bank, a real important bank that is pushing for this to be used on projects around the world. So they're a major player, and they simply adopt the DAB approach. And then the Dispute Resolution Board Foundation, the DRBF, which trains adjudicators in all forms and trains the adjudicators for FIDIC. So dispute board procedures now, well, there's quite a few of them. So there's the AAA in America, and they have the DRB approach. You can look it up for free on the internet if you want to see how that works. That's the Arbitration Association of America. And then you have FIDIC's approach. So don't forget you've got standing or ad hoc in the old 99. You can look in the contract. The procedures are set out in the contract. Procedure is at the back in the appendices. The ICC rules there. Then the ICE, the Institution of Civil Engineers, I think was feeling left out. So they introduced an 84-day procedure and a 28-day procedure. So this is to comply with the English legislation, which requires an adjudication to be dealt with in 28 days, very fast. Then we have the CIR one, which is a DAB or a DRB, purely an 84-day process for international use. Most recently, The JCT, which is an English institution for building contracts, produced a 21-day DAB procedure. They only launched it on the 4th of May, just recently, and we're about to launch. I was involved a little bit in that. They're about to launch a short video about how it works and the document you can find on the JCT's website. So there's a fair few procedures out there now, but the most important one has got to be the FIDIC one. Currently still 1999, most widely used, perhaps one day 2017. Takes time for people to adopt new contracts. So what's the role? Well, the role is to keep abreast of the project and the developments on the project, visit the site and produce short site reports, and encourage early recognition of problems and try to get the parties to talk about them. And if a dispute is resolved, then the dispute board falls into its more formal procedural approach, I suppose, issues a timetable, because the decision has to be issued in 84 days. So there's not long to get a response, a reply, maybe go to site, perhaps have a hearing, although we tend to call them meetings. Hearings have quite a formal kind of sound to them. You know, are we in arbitration? Not really. What's the difference in practice? Well, I prefer really, if I'm on a dispute board, to have a meeting where the dispute board asks the questions of the parties and maybe has presentations, not cross-examining witnesses or experts, but get the experts together. We might call it a hot tubbing approach to discuss particular topics. So it's a bit more informal. And then they have to complete their deliberations, so they don't have long to write their decision, or within 84 days, compared to international arbitration, where you could be spending a year or 2 or 3 going through this process, but of course in a lot more detail. So what are the elements of success? This is the list that the DRBF considers is appropriate, and I agree. So first of all, dispute board members need to be impartial. They shouldn't be linked to the employer or the contractor. So they've got their own independent view. Of course, they are only really there by virtue of contract. So they each have to sign an agreement. So if I'm a dispute board member, I'll sign an agreement with the employer and the contractor. So 3 of us sign that, which means that I then am contractually the adjudicator, and they are bound by my decision. So you'd have 3 of these 3-party agreements to form a DAB with 3 members in it. So you'd have 2 wing members and a chair. And I think it's really important to have them at the outset. I don't really like the idea of ad hoc when a dispute arises. I mean, it does the function, they make a decision. But if you're going to make the most of the avoidance part, then you need to appoint them at the beginning so they get to know the project and the people. The fees are shared equally. I think that's important, and that helps with the appearance of impartiality if both parties are paying equally. And they keep up to date with documentation and regular site visits. So either party can refer a dispute to the dispute board at any time, and this means, of course, then that the contractor can or the employer can. So they have the ability, or this power, as it were, to bring in the dispute board to make decisions if they're arguing about something for a year or more, which is typically what we might see. Extensions of time, additional costs. Was a particular item a variation? When should the design have been approved, and has that led to delay? Is there a defect in the works that the contractor should be putting right or paying for? These are all typical things that we see on a dispute board. And of course, it's very important, number 7, this is the natural justice point, that the parties have an equal opportunity to present their case. The dispute board can't just listen to one party or the other. They need to do everything together with all of the parties. So, you know, you really need to have both the employer and the contractor at a meeting. It's quite important to have the employer there, not just the engineer. There should be a representative of the employer. Then if a decision is required, it needs to be reasoned so the parties can understand how the dispute board reached the decision. And also, finally, then, the dispute board members are absolved of liability arising from their activities in the same way an arbitrator would be. And this is to stop a powerful party bringing a claim against an individual or dispute board members, really to disrupt the dispute board process. It can be quite a powerful way to interfere with dispute boards to threaten proceedings against them when they're simply carrying out their duty. So there's immunity from those sorts of problems. Myths and benefits then. So some people say the dispute board just imposes its own ideas about fairness and equity. Well, that's not really true. I mean, obviously the dispute board makes a decision about what they think is fair and equitable, but that is based on the contract, what the contract requires the parties to do, and the applicable law, and who might be in breach, and so on. So they're just applying the contract as would a judicial decision maker, as would an arbitrator. The presence of a dispute board will promote claims. Well, I'd agree with that, because the idea is for them to avoid claims. I think some people think because you've got a dispute board, we might as well create disputes and send it to them. Or if we've got a dispute, we may as well send it to them. But the other way, of course, of looking at it is that if you discuss and negotiate for many years a claim and never settle it and end up in arbitration, it would have been better to have had the dispute board make a decision about it much earlier on. The presence of the DB will promote acrimony, and it will make the parties contentious. You know, I find it's actually the other way around. So imagine you've got a project that's been running for a year or so, and the parties have started to fall out. When the dispute board turns up for its once every 3-month meeting, there's a much greater chance that the parties will be civil and nice to each other when the dispute board is there. It's interesting. It takes a while for them for their guard to come down and start generally complaining at each other with the dispute board there. So actually, I think it helps communication. And the dispute board, of course, can ask those difficult questions. It can ask, well, why have you adopted that position? And why is that late? And what's happened to that activity? And tell me about resourcing and workplaces. And, you know, it's got to be practical stuff. But they can help to build the relationship again by taking the parties through the problem and into solutions. And tasking almost the parties with solutions, and maybe coming back to them with a virtual call a few weeks or a month later, rather than waiting for the whole 3-month cycle. That can be done effectively. Myth, another myth. Dispute boards don't work because they lack the formalities of legal process. Well, that's not true, because the dispute board follows the project factually. But they have to make they have to make any decisions in accordance with the contract. So the dispute board is there to apply the contract, and they will follow legal processes. So it's really important that dispute board members have those skills, engineering and legal. I think the best dispute boards comprise a construction lawyer and maybe 2 construction professionals. Those are the best ones that I sit on. It's often quite good to have a lawyer to manage the process and think about some of the legal problems. And of course, the engineers that are on the panel will usually, in my experience, be pretty good on the law anyway, but they'll technically know things that the lawyer won't know. And again, the lawyer will understand difficult or jurisdictional challenges that the parties might make in order to sometimes bamboozle a technical panel of 3. Oh, there we are. So now, just then looking at some statistics. So you're probably thinking, well, if you've never come across this, then does it get used? And the DRBF, the Dispute Resolution Board Foundation based in the States, has some statistical data. I've just plucked out some of it now. Going through from 1988 to 2005, they looked at 1,300 projects worldwide with a total value of 95 billion. Average number of disputes per project, 1.3. 60% of the projects with a DB had no dispute. 99 of the projects with DB recommendations did not go on to any subsequent litigation or arbitration. And then we have some other stats there. 2,800 projects looked at during a slightly different, longer period with a value of 275 billion. 85 to 98 were resolved without arbitration or litigation. So a high success rate in relation to large projects. Are DBs effective then? Well, some more research was done, and you can have a look at this. It's on the DRBF website in relation to the Tokyo 2018 conference, and they sampled 231 boards before the conference over a period of time. And what you can see there is that the dispute boards are actually being widely used in Eastern Europe and in Africa, and a fair amount in the US and Canada, but not so much in other parts of the world, but they are slowly growing. If you're in the Middle East, you can see, look, not very much at all. The MENA region has a very low take up of them, which I think is unfortunate. Maybe we'll see more of that one day, but certainly they're effective in the places that they're being used, and it's a shame they're not being used perhaps more. I'm just going to talk to you very briefly about a project that I'm currently involved with, and this is CERN, the Nuclear Research Facility, which sits in Switzerland and in France also. So you can see now, if I just put the laser pointer on, you can see here that you have Switzerland over here, France here, and the yellow shows the underground tunnel. So this is the Large Hadron Collider, as it's called. So basically what they do at CERN is research the very tiniest of matter. They crash protons together to split them apart to see what they're made of. What they have done along the way is produce some very clever bits of equipment. For example, the scanners that are used in hospital, a lot of that was all developed through CERN because of their need to try to capture detailed information about what's inside atoms and so on. So a lot of good medical research has come out of what they do there. For those of you interested in matter, the Higgs boson, for example, was explored by them and discovered by them some years ago. Now they're increasing their project. They're spending €1 billion, and it's 2/3 of the way through. And as you can see straight away, for those of you that are thinking about the construction aspect of all of this, immediately we've got two jurisdictions, haven't we? We're sitting in France and we're sitting in Switzerland. So we've got two access points, one in France and one in Switzerland, at point 1 and point 5, and this allows you to go underground about 80 meters to get access to the equipment. So if you then look at what's actually going on underground, you can see the tunnels where they fire the protons around, and the equipment that is used. So there's very large magnets, very powerful magnets, most powerful in the world, as I understand it, that keep these protons within the tube, and they gather photos, for want of a better word, of the impacts of the protons, so they can see what energy source is the energy source that makes up these protons when they split apart. So when they started this project, so the upgrading works, in order to improve their facilities some years ago, they appointed a panel of adjudicators. So this project is unusual in that there are 5 adjudicators, and it's FIDIC based, and there is one chairperson, and I'm the chairperson of this panel. I suppose I'm representing dual qualified as a primarily lawyer, but also dual qualified in construction. And then we have 2 tunneling experts, an architect and another pure lawyer. And so this gives quite a nice range of skills across this project. And it was the employer that drove this. The employer was very keen to have dispute board on this project, which sits across 4 contracts with 2 jurisdictions, and to have a range of skills, and the contractors have all accepted it, and the engineers have worked with it. And it's an interesting project. So I think it shows that you can really make this work well. Another good example is Caltran, the Californian Transport Authority. They've been running dispute boards for 20 years and use them throughout all of their projects. Have a look at some of their information on their websites and on the DRBF website. It's been very successful. So in that, there isn't lots of litigation after the projects. They solve everything job site wise, and that's the idea of this if you embrace it. So FIDIC appointments, how does it work? They're under the contract. Well, the FIDIC contracts provide us sort of an all-embracing contractual process for the dispute board to work between the employer and the contractor, but it also has to include the appointment. So clause 20 of that contract says that the dispute board will be engaged at a date set out in the appendix. And if it's the red book, it's within 28 days of the commencement date by default. And either 1 or 3, you tick the box. And the default ends up being 3. And the default appointment by FIDIC, if you can't agree who your members will be, FIDIC will then nominate your dispute board of 1 or 3 or any missing people. So don't forget that the yellow and silver, they only have a DAB when the dispute arises, but from 2017, FIDIC now has changed that, so you have a standing board and you have all the benefits of a standing board. There's a tripartite agreement in FIDIC, so you've already got the form of agreement between the DAB member and the employer and the contractor. The procedural rules are there too. This is the stuff about how the powers of the dispute board and the time periods. And then there's the FIDIC President's List of Adjudicators. There's about 70 people on that at the moment, and I'm one of the FIDIC adjudicators. The list has been opened up for expansion, and I know that the candidates have already applied for that, and I think they'll be asking for more soon. And I'm currently the president of the DRBF, so we're training and assessing those people across the rest of this year, actually, for FIDIC. So if you're interested in being a FIDIC adjudicator, now might be your time. This is the claims and the dispute resolution procedure in FIDIC. And I think just, there's several things really to note about this. First of all, you have a pathway in FIDIC that takes you from a claim through the dispute board and then eventually to arbitration. You can't jump to arbitration. So the idea is that you go through the dispute board and hopefully that resolves the problems there and you never end up in arbitration. That's the theory. Of course, it doesn't always work like that. But that's really the emphasis now compared to 20 years ago. So it's a great emphasis. Job site dispute resolution wherever possible. And then if you look at this process, you should start out with an engineer making a determination. So if a claim for time or money is brought, then the engineer would make a determination about it. And your notice of claim needs to be put in, and this is your clause 20.1 point. It's a condition precedent. In other words, if you want time or money for any claims that you make, then you need to ask for time and money, otherwise you might lose your rights. So you see this sort of cycle of clause 20.1 claims, determinations being made about them, and after that you then get a formation of a dispute. If the engineer's determination is either not given, you end up with a dispute because there's a breach by not giving it, or you end up with a determination that perhaps, say, rejects the contractor's claim, and then there's a dispute about what the contractor really wanted. And then it can be referred to the DB at any time. Then you have to ask yourself, don't forget, if you're under 1999, whether the DB is already there or not, or should be there. I see plenty of red book contracts where the dispute board has not been appointed, and a dispute has arisen several years later, and you have to actually appoint them to then progress this whole process. 84 days, don't forget, very quick to make a decision. There's a written decision. If you don't like the outcome, either party can serve a notice of dissatisfaction, but it has to be served within 28 days of the decision. Now, if there's no notice of dissatisfaction, then the decision becomes final and binding. And if a party doesn't comply with it, you can still go to arbitration, but the idea is you go to arbitration for prompt enforcement without reviewing the merits of the claim. There's lots of arguments about what you actually do, and I'll look at those just briefly at the end. But if there has been a notice of dissatisfaction, then you would first of all have a period of 56 days for amicable settlement. And then if you don't settle it, you go under clause 20.6 to arbitration. The difference here is that the arbitration is about open up, reviewing or revising the whole of the decision. So it's not an appeal from the adjudicator's decision. You just ignore that and you rehear the dispute afresh. So as you can see, there's quite a pathway there to take you by contract, through the contract, no matter which country you're in, through the dispute board, to a point where you've got a decision and an outcome in relation to the claim or claims that have been made on the project. Now, sometimes claims are made, they're gathered up and sent to a dispute board, perhaps in several tranches. Notices of dissatisfaction might be issued, and then the parties just decide to settle it or live with the outcome. Sometimes no notices are settled, and that's the end of the matter. But it's more common, I think, for parties to reserve their position with the notice in case they need to have a bit more of a fight about it later on. I think that the best success is really had when the dispute board follows the project from the beginning. Let's have a look at this timeline in the way that FIDIC displays it. And this is FIDIC's little timeline, their chart here. We don't need, I suppose, to pay too much attention to the start of this. This is about appointing the DB, hopefully then under the FIDIC Red Book at the beginning. But here we have a party refers a dispute to the dispute board. The parties present their submissions in this 84-day period. So just this diagram, I think, helps us to focus on what happens here. Quite a lot happens in this period. You know, the dispute board receive a referral, and then they're going to issue a timetable. It might be they want more details about the claim. Sometimes the referral is nothing more than, we want this much time and money. So where's the detail? The referral should ideally be a full and proper statement of claim, together with any documents relied upon, programs relied upon, experts' reports, a witness statement, if that's helpful to explain what's not in the contract and can't be easily seen from the correspondence. And then that allows the dispute board to get quickly up to speed. It allows the other party to know exactly what's being claimed. And then it allows the dispute board to set a date for the response, which could be 3, 4, maybe 5 weeks. It can't be much later than that, because there needs to be a chance for a reply, a rejoinder possibly, if new issues arise. There needs to be a chance possibly for a site visit and a meeting. And you still, you know, if you're having a site meeting here, you still need to have some time at the end before the 84 days to write your decision. I find it quite helpful if I have a meeting with colleagues sitting on a dispute board. I find it quite helpful to spend an extra day trying to work out what we think the answer is and drafting some parts of the decision rather than going away and then debating it later on. Can be quite helpful to try to work out what you think the skeleton of your answer is, and then you've probably only got a week or two to finish drafting it anyway after the hearing. But that's where you need to set out your logic and your reasoning for the decision. And there's the 28-day period for the notice of dissatisfaction. So if there's no notice of dissatisfaction, well then the matter is final and binding. If a notice is issued, there's a 56-day period for amicable settlement before you can go to arbitration. So the other thing to remember here is if you have finished a project several years ago, you've got lots of claims, but you haven't dealt with them, and you suddenly someone wants to arbitrate, and there's a DAB provision in the contract. You have to go through this process first before you can get close to beginning a valid arbitration. So the 2017 contract is a bit more complex. What has changed? Well, first of all, they've split claims and disputes into two separate clauses. So we have Clause 20 dealing with claims for time, money, and another relief. In other words, reviewing certificates, for example, or making declaratory decisions. In other words, explaining what the contract really means. And these are just disagreements. So a notice of a claim as a condition precedent triggers the engineer's initial response, and then you get a fully detailed claim. And we have to set out the legal basis of your claim, and that's also a CP, a condition precedent to you continuing down the pathway of dispute resolution. Your fully detailed claim needs to be based on contemporary documents, the records at the time of the problem. And then you either reach an agreement within 42 days, or if not, the engineer has 42 further days to come to a written decision. And if this is an ongoing claim, of course, then every month you have updates and assessments of this claim until it eventually ends. Now, that might be the end of the matter. But if not, if there's a dispute, then that dispute would form under Clause 21, and you would refer it to the dispute avoidance and adjudication board, which is what they're now called under the new FIDIC, emphasizing the avoidance function. 84-day procedure, identical. Written DAB decision, notice of dissatisfaction is just the same. Now, a couple of other things, though, just to say in relation to the arbitration, they've made it clear that if there's no notice of dissatisfaction, then the parties should comply with it promptly. And if an arbitration is commenced, then the arbitrators could use a summary process, an expedited quick process to issue an award, forcing a party to comply. What about enforcement then of decisions? Well, I think it's worth just saying, if you have a look in the ICC casebook, so this is where they publish arbitration awards with the names deleted, so you don't know who the dispute was between, but you can see what the dispute was about and how the arbitrators decided it. So there's one case here going back, this case 10,619, and this related to an old FIDIC version, but basically it makes it clear that arbitrators can enforce immediately decisions of of the engineer in this case, and therefore the same goes for adjudicators now. And then we have this case involving Pesaro in Indonesia, and the Singapore court grappled with arbitration awards, and the DB decision was not honoured, but it is clear after several rounds in the courts and an appeal decision that the DAB decision can be enforced with an arbitration award. The arbitration award simply saying pay up now as damages, and then the tribunal can go on and consider the merits over a year or two. So in other words, you can't use arbitration as an excuse not to pay up, but that's still something that we're grappling with internationally. Anyway, that I think covers most of the points I wanted to make, and so I'll stop sharing my screen so hopefully the questions appear, because unfortunately that didn't seem to work. I couldn't see the questions, I'm afraid. So let's have a look at them as they've come up. So could you please advise jurisdictional challenges in the MENA region that parties may face in terms of DAB's decision? I was like, yeah, absolutely. So I've dealt with lots of these. So one of the problems we see is that it's hard to get the DAB appointed. Often parties don't or can't seem to agree on the dispute board or find appropriate people. And then when they do find them, the other party just refuses to honour payment, assuming that's the way it's gone. And what you have to do is go off to arbitration and try to get this initial award. Now, I have had a situation where in the Middle East where the appointing body of FIDIC had been struck out and the arbitration had been struck out. So basically it said you had to go to the DAB and find the DAB by agreement and then go to the court if you didn't like the outcome. We spent a year trying to agree a DAB and couldn't. The other side was just strategically avoiding ever getting a decision in place. Now, the claim was about $50 million. 20 million was unpaid certificates. So we went off to the court and said to the court, please, can you appoint a DAB for us, because we can't seem to, or nominate someone that could, like the local arbitration institute, to appoint a DAB. The court did this. They listened to the parties and realised the other side was simply just trying to delay everything, and they appointed a court-appointed expert, because the judge said, I'd never come across this before, don't know what to do with it, but I'm going to get a court-appointed expert that's an engineer to look at it. So the engineer then was appointed by the court, understood what the FIDIC contract was all about, and then appointed 3 people as the DAB, which the court then approved. Interestingly, the court expert said that in relation to the claim of 50 million, 30 million was disputed, so should be looked at fully by the DAB. But in relation to the 20 million unpaid certificates, he thought that wasn't really a dispute and that they should just be paid, so gave it back to the judge. And the judge said, quite right, there's no dispute about these certificates, pay the 20 million and then go off to the DAB for the 30 million. It took about 18 months to get there. But the court did get there by use of this local expert. But it's very difficult. You don't always know what's going to happen. And then there's a follow-on question there. Could you please advise how a DAB member is to be involved in the FIDIC President's List. Ah, okay, yeah. So, and whether the DRBF training has already started or not. Well, have a look at the FIDIC website. So FIDIC has now developed a new institute called the FIDIC Credentialing Limited, which looks at the credentials for engineers and adjudicators. So at the moment, the live part is for adjudicators. Have a look at the website. They just did a round of applications, which basically is done in 2 stages. The first stage is a sort of a multiple choice question, which has already gone, but there'll be more coming up. And if you pass the multiple choice questions phase, then you go on to do a series of essays and a mock adjudication. And the first one of those is just coming up now, and there'll be more of them, I think, September and November this year. So do please have a look at the website. An example of the timetable for 84 days would be helpful. Sure. I mean, if the parties, unless the parties have agreed anything, I tend to go for 4 weeks for a response, 2 weeks for a rejoinder, and then 1 or 2 weeks for a surrejoinder, and that then takes you about 7 weeks or so in, and then I would fix around week 9 a hearing, and then that gives me a couple of weeks to write a decision. And if the parties want more time, then I want them to agree to extend the 84 days. I can't, as an adjudicator, extend the 84 days, but all 3 of us can agree to extend the 84 days. If the parties won't extend the 84 days, they have to make their submissions within my timetable, because the adjudicator is in charge of the process. The parties are in charge of their dispute, but the adjudicating, the DAB, is there to set up the process. John Leonard's question, would you favour a compulsory adjudication by legislation or statute on every construction project contract rather than in contract provision? What will be the implications of it? Okay, so one of the problems in England is we have this great adjudication process, but you have to comply with the legislation. So it's 84 days, a dispute at any time. So you can't have a FIDIC pathway. FIDIC doesn't work in England. And I think that's a bit unfortunate, really. You know, it's unfortunate to have a country with one set of rules and then say another country and another country. New Zealand's different to Australia. Australia is different to here. Singapore has a different process to Malaysia. So there are already different approaches around the world. So I do quite like the idea of there not being legislation, because it allows you to have a contractual process. The problem is that you can strike it out of your contract and it's gone. It would be good to have a international treaty for enforcement of them, like the New York Convention, for example. It would be good to have something like that, or in the UNCITRAL model law, to have a provision for enforcement of DAB decisions. That would be quite good too, because what's needed usually is just support for the DAB process, which is why legislation can be helpful. So you can see it's not an easy answer to your question, John. Hopefully that does try to answer it. Thank you. Ah, yes, so if one party refuses to acknowledge that a dispute exists and intends to delay the process under the FIDIC DAB process, what would a proposed solution be to progress it? So, well, the great thing is that if a dispute exists and you've got a dispute board, you can refer it to the dispute board, and that sets the 84 days running. If a dispute exists and you don't have a dispute board, then obviously what you've got to do is get the dispute board in place. So usually the best thing to do is to write to the other party saying we need to appoint a dispute board, look at clause 20.2 in the contract. We propose this person. Why don't you propose someone? And then they're supposed to propose someone. There's a time limit set out in the contract. If they don't propose someone, you can't appoint someone, then you ask FIDIC to appoint the missing person. So they will appoint on behalf of the other party. FIDIC will engage in looking for someone, checking conflicts, writing to the parties and saying they're doing this. And then once that person's in place, then those two can try and agree with the contractor and the employer who should be the chairperson. And again, if you can't get one of the parties to engage, FIDIC will appoint that missing person. Then you will have your 3, then you make your referral. But you know, one of the things that can happen when you start doing this is you get the other side to engage in the dispute discussion as well, because they realise you're heading towards solving the dispute. Maybe they'll come back to the table. Perhaps they thought their view was going to prevail. Now they realise it might not. Of course, you know, you can sometimes spend a year trying to get the whole DAB in place if you know you are discussing potential people and trying to negotiate. But you know, this is something that goes with the strategy of deciding what to do. And it makes you realise it's really good to get the DAB in place at the start of a project when everyone's getting on with each other. It's really easy to appoint a dispute board at the start because the people are getting on. You know, the contract says you are to have one. Let's look at some potential names. Let's look at their terms and how much they charge, and let's get them signed up in case we need them. And I've sat on projects where I've not been used for years. They haven't even wanted to do meetings, bizarrely, and then suddenly a dispute arises. I've got one now, actually, where I've just had referrals arrive. It's the fourth referral, and claims, I think, 7 through to 14 are listed in it. So the others were sort of the bigger ones. Now we've got a little collection of leftover ones. Project finished a year ago, a year and a half ago now. Which is unfortunate because the parties are using the dispute board, and this can be useful for you, because I realise many of you are in this situation where you need to get the dispute board in place to get an answer to claims you've been negotiating for a long, long time. But I suppose my final message would be, for new projects, try to get the dispute board in place. They'll help avoid dispute. You still write your claims, but the dispute board helps you kind of resolve them, because there's always going to be claims and problems on projects as far as I can see. And then if you can't get a proper settlement with the other party, then the dispute board can make a decision, and at least everything moves on, the project moves on, and life moves on, and you avoid, hopefully, spending 5 years negotiating after completion before you see any money, which, you know, can be typical of some difficult international projects. I'm sure many of you have seen that. Gary, the New York Convention forbids the imposition of heightened requirements arbitration to be valid. However, that's a really specific question. It looks, Gary, like you've got a particular problem that you want some drafting for. I think, you know, I think it's really difficult in the UAE. Actually, I think it's really quite difficult and a bit unfortunate. As I say, you know, I have had success with judges there that get it with an expert, as it were, but I've also seen rather strange experiences and rather slow experiences in the UAE. It depends on which judge you get and what expert they appoint when you come to look at these questions. But I'm not sure there's an easy answer to this, because and this isn't just the UAE in relation to powers of attorney, and there are some countries where the law requires formally signed appointments before the DAB has any power, because it requires formal appointments for contracts, and that's just the way it is. So it's not just the case of needing powers of attorney sometimes, and this can be a real problem. For 2017, FIDIC has tried to draft around it, but I'm not sure that that's quite the answer either. As I say, you know, if you can appoint a DAB at the start, that's the way to do it rather than later on. John Leonard, what will be the role of the engineer in relation to DABs resolving a dispute? Can they consult? You know, the engineer is really important in relation to resolving disputes for 2 reasons. One, under the contract, they are supposed to help the parties try to reach an agreement. So they've actually got a role to play, and they're supposed to do that. Secondly, if they make a determination, they still would be invited along to the hearing or the meeting with the DAB to assist. Now, it may be they turn up to represent the engineer. Sometimes that happens. Or it may be they turn up just because they've got a point to put across about their view. And sometimes as a DAB, you find you've got the contractor's view, the employer's view, and the engineer's view. But it's really helpful to hear it all, because then you get not just the positions of the parties, but the engineer can help set out the facts as they see it. And sometimes that can be really quite helpful, because you may have a contractor's technical position and an employer's simple rejection, and you might need some more facts from the employer's side to really weigh up what's going on. And the engineer might then be able to help you with that. And the DAB should then come to a more informed and better conclusion. I always like to see the engineer definitely at the site visits and definitely at the hearing. Can we use FIDIC for different forms of contract? Yeah, absolutely, yes, and they are being used in DABs are being used certainly in IT software contracts. You know, these long contracts where software is developed over a period of time, they work effectively there. We're going to see DABs used in other areas too, other commercial long-term arrangements. Determination needs to be signed off by all parties in DAB. No, so a determination made by the engineer under clause 3.5 is just made by the engineer, and that's that. The DAB can open up, review it, and change it and ignore it. When the DAB members issue their decision, it is binding on the contractor and the employer. The engineer-employer have already, in the contract, agreed to be bound by it. That means the engineer is bound to comply with that decision when they go forward to the next certificates. They can't ignore it. So if the DAB makes a decision that there is a 1-year extension of time and $10 million to be paid, then actually what the contract requires the engineer to do is to recognise that extension of time and include that $10 million in future payments. Now, sometimes they do that, sometimes the employer tells them not to, but there we have the fun and the games that you get with these things.
Because it seems that that's the last question.
Brilliant. And we're right on time, aren't we? That's amazing.
Yes. Thank you very much for your time, and thank you very much for insight into this very contested topic and very interesting topic. You're a man of huge insight in this, and I'm sure the participants have enjoyed. So thank you once again. We appreciate you taking the time.
Well, thanks very much. And if people have got questions, they can always drop me a message. And I hope one day to see some of you on the dispute board, either me sitting on it or being there somewhere. And in the meantime, you know, stay safe and keep well. All the best to you all. Thank you.
Thank you, Nicholas. Thank you. Bye-bye. Thank you, everybody.
Thanks a lot. Bye-bye. Bye-bye.